have an appeal, ZBA application, appeal, I should say, 15-030, appeal of the decision of the zoning enforcement officer regarding the Shoreline Farms and the granting of a split in the property. Mr. John Lambert, I think, is representing the adjacent property owner. Is that correct, Mr. Lambert?
Yes, I am.
Okay. Would you like to present your position?
Well, yes, I would. I'm a little concerned about the late hour here. I'm concerned that whether you will let this go long enough that we can finish it. I'm prepared to begin.
Yeah.
But I see 4 attorneys here. There's going to be witnesses, and there's the right to cross-examine witnesses. And I don't expect it to be less than an hour, probably more. So it's about 11:20 now. And I bring to your attention, for your counsel, the notice of this refers to Shoreline Farms LLC. There is no such thing that I know of. The owner of this property is Shoreline Gardens LLC. So I don't know whether that's a defective notice. That's not the legal statement. In that case, if I may begin, and will we be allowed to finish tonight? Or?
Well, we'll hope with this one, Lambert. We'll see how it all works out. I mean, we want to get this thing completed as much as you would.
Very well.
Yeah, we can get it right. I see John over here is getting antsy, but Mr. Fitzwright is still here?
Yeah, I think so.
Will he still here?
I think so.
Oh, we give him the keys. Okay. All right, Mr. Lambert.
Thank you. My name is John Lambert. I represent, I'm a lawyer. I practice in North Haven, Connecticut for the past 35 years here in Connecticut. And I represent essentially more or less all of the people who have got the property or are adjacent across Old Road. I would withdraw on the appeal the name of Hope Douglas. I spoke with her today and she'd rather stay out of it. So the other people I represent, that I represent, and one of the things that was a staff comment here, well, let me give you an introduction. All this appeal about is whether the approval by Mr. Knapp of a lot split, of a large lot that's existed for at least 140 years, met with light zoning. That's all it's about. Specifically, it's whether lot number 2 has adequate frontage. We have no quarrel that lot number 1 or lot number 2 would have adequate size under the zoning regulation. It has to do with whether lot number 2 has adequate frontage. So this case is not about whether the owners of Shoreline Gardens are nice or not nice, whether my clients are nice or not nice, or whether Mr. Knapp is nice or not nice. It has to do with whether he made the correct decision. And it is our position that he was given bad information and therefore made an incorrect decision. I spoke to him. One of the things in the staff comments was we need to show timeliness. The decision was made on the map. You'll see that the map was signed on June 29th of this year. The map's dated, I think, June 25th, signed and received by the town clerk on June 29th. You have a rule that modifies the statute that would give someone 30 days to appeal, 15 days. That runs, though, however, either from a publication or from actual notice. I found out about the approval on one of the evenings that the town hall was open late. In preparation, it was supposed to be, Shoreline Gardens had a special exception application that had not been heard in late June and was kicked over to August 3rd. So I was looking on July 30th during your late evening hours and found this map that had not yet been photocopied in a way that I could get a electronic version. It was still in only large form. So the next Wednesday, that was July 30th, the next Wednesday, I spoke with Mr. Knapp and said, would you reconsider this decision? I said, absolutely, but your 15 days ends on August 14th. I can't guarantee you that I'll get to it in time. You better file an appeal. So we filed an appeal under my version of what is required by the statute. That's the thing called notice of appeal in your packet. And then to follow up, because you have a form. I had one filed timely by the 14th by Mr. Conti, who is an abutting owner, signed by him, signed by me, and listing everybody else. So I would submit to you that this appeal is timely. It was within 15 days of actual notice. I did look through, for example, the Harbor News, and did not find any publication of Mr. Knapp's decision approving the map that would have caused the time to have run sooner. So I have for you, the first thing is sort of housekeeping, is various signed confirmations of my authority to have done what I did. Frankly, my position is you have no ability, no right to demand that my client sign an application. They don't have to sign a complaint in court. I can sign it. But the claim is that how do you know that I represent them? Well, I have here most of them signed, ratifying, confirming my authority to have brought the appeal. It was signed by Angela Navarra, Peter Navarra, Dale Moore, also known as Dale T. Ventinen. These are all names that show up on the map that we are contesting. Donna Stepanakis, these do not. Donna Stepanakis and Charles W. Stepanakis Jr. are across Old Road at the start, near 145. Pamela Fritz is also not shown on the map, but she is directly across the road next door to Stepanakis on abutting Old Road. John R. Conti, Karen E. Conti, they're on the map. Justin Winans and Teresa Winans, and then Mr. and Mrs. Nazato, again on the map. I'd like to submit those and tell me whom I submit to. I am not certain what you have, because when I asked what was handed to you, the email I got was simply referred to emails, but it didn't, there were days that were there conditional. So I guess I would ask you, in your papers, do you have my letter to Mr. Knapp to reconsider his decision? Is that part of the record, or is it not?
I think we do. Yeah, you have that, George? Yeah, I know. Yeah. We have this letter.
Okay, just to confirm, this is a letter dated 11 August. To attention, Mr. Knapp, Eric Knapp?
It's 12 August.
Okay. Then I may be using a earlier version. On the first page, by the way, I have some highlighting, and I have lots, on my version, I have Lot 1 being entirely located on Old Road, and Lot 2 located on Old Post Road and Old Road. It's the opposite. Lot 1 is located a tiny bit on the Old Post Road, and otherwise the frontage appears to be on Old Road. Lot 2, the larger lot, is entirely on Old Road. So if that's the case, we can go, and I assume, may I assume that people read their packets thoroughly? Because I get that we can speed things up if I can assume that this is part of the record.
You may want to summarize.
Well, and I will.
Yeah.
But I guess the main point I wish to make is to go to the documents, the set of documents that I submitted that go from 1969 up to 1992, and why I believe this was an error. The documents begin with, well, I'm going to go a little bit out of order. Those are the key key document, but in addition to those, I'm not sure that submitted was, in going to the state of Connecticut, and I'll submit these, but I want to summarize them right now. Went to the DOT, called the DOT, and asked for what they called, used to be called TR maps that are now called TRU maps. As old as they had for the town of Clinton. What did the town of Clinton claim as road? The oldest map they had was a 1954 TR map that showed a very small portion of what we now call Old Road as an improved road. Sort of the area, perhaps, of what is being claimed today, the paved portion. That referred to it as then as Brush Hill Road number 2. That was the town of Clinton's reference to this road, Brush Hill Road number 2. Very short, 1954. On that map, there was a reference to the center of town, and it said, see TRU map 27. TRU maps are urban maps, and so the downtown of Clinton, even 61 years ago, was not on the TRU map. It was so dense, so many streets. It was on the TRU 27 map. In the papers I have here, I start with 1969, and Mr. Flaherty, who I guess I'm assuming was sort of a consulting engineer to the town, probably when you didn't have one. It's an assumption on my part. And he is saying to the town, this is not a good idea, let's not build on it. And of course, towns don't necessarily listen to their experts. But that's 1969. 1974, in 1971, and this is not in these documents, but I will submit them. In 1971, the town sent a list of roads to the DOT, and it listed Brush Hill Road 2 as 0.06 miles of improved road, and did not list any unimproved road being claimed as a town road. 1971. 1972, Brush Hill Road number 2 disappeared completely and has never appeared again. No Old Road, no Old Brush Hill Road. 1972, the town no longer reported this and claimed any portion of Old Road as a town road. In 1974, you have before you in the list of documents the notice of the selectmen having passed an ordinance in which they listed all of the roads in the town and said anything not listed is discontinued. I have to stop for a second and go through sort of the law of discontinuance. For 200 years, discontinuance, the only agency that can discontinue a road is the selectmen. Statute, the selectmen may discontinue a road with the approval of the town. Usually that means the town meeting. In this town, it would be the town meeting. At that time, however, 1974, your charter allowed the selectmen, instead of just being an executive body, the charter allowed them to pass ordinances. So, quite arguably, the selectmen were the town, and therefore they had two hats, and their discontinuance of Old Road by not mentioning it, not mentioning it as Brush Hill Road, not mentioning it as Brush Hill Road number 2, not mentioning it as Old Brush Hill Road, was effective as a discontinuance. Becomes sort of moot. It is for my purposes, it is most important for the evidence that the town, by 72, says we want nothing to do with this road. We wash our hands of it, whether they have the right to do that or not. By 1974, the selectmen say, we who hold all the power in the town discontinue. And I might say to you, there are towns where one entity can do both functions. The town of Hamden no longer has a selectman, they have a council, and the council took over the selectmen's highway duties. So the council is the town when it comes to legislation, and it's the selectmen when it comes to the discontinuance. So it's not unusual. 1974, the town clearly has acted through its highest elected officers saying we truly want nothing to do with this road. I'll submit maps 1986, 1994, and 2010 that submitted to the state of Connecticut that show nothing for Old Road. And these became either TRU maps or TR maps, and there's explanation on it. But I get ahead of myself. In 1989, the people on Old Road went to the first selectman, who was then Virginia Zavoy, I hope I'm pronouncing it correctly, and wanted the road discontinued, and got a letter, and it's in your materials. The letter says, Mrs. Zavoy says, I've consulted council. We don't think Old Road is a road. We don't think it ever was a road. Which, by the way, I disagree. I don't believe it was a road and needed discontinued. We don't believe it was a road. But council that she referred to said, well, there may be a problem with this 1974 thing, and it's all in there. Clearly, she does not want anything to do with it. You have in there excerpts from 3 meetings, that's in June of 1989, 3 meetings in a row of the Board of Selectmen, where the residents of Old Road come and discuss it. It's on 3 consecutive meetings of the Board of Selectmen in July of 1989. And in the last one, which is July 19th of 1989, the selectmen say, you know, we're having a special meeting in a couple of weeks on another matter. We will add this so that the town meeting can get rid of it. And next thing we put in the documents is the notices that went into the newspaper of the special town meeting and the resolution to discontinue Old Road from 145 to Brush Hill Road, the whole road. You have the minutes of the meeting, and the minutes of the meeting say that resolution number 2 came up, it was discussed, it was voted upon, and it was unanimously passed by the town meeting, your legislature, to discontinue Old Road. So we have an act in 1974, the selectmen saying clearly we don't want it. Evidence irrefutable, they didn't want anything to do with it. We have the town finally giving its approval in 1989, following, by the way, the selectmen clearly not wanting to take care of Old Road. They sent the resolution to the town meeting. They wouldn't send a resolution to the town meeting that they wanted voted down. Everything in there suggests that they wanted this done and over. In following the discontinuance, Jamie Frechette's father, Roger Frechette, a great litigator, Jamie Frechette was turned down by P&Z for a subdivision on Old Road because it wasn't a town road. And the house would be the one, Pope Douglas' house. He appealed it. And in there, the stipulation of, he brings it in early 1990, and by mid-1990, P&Z is met. They've stipulated to a judgment, let him have it, let Jamie have this, but he is to, as soon as he gets his house, he is to improve the road and then seek its discontinuance. It's unclear whether how much he ever improved it or whether he really sought its discontinuance. But in 1992, after 1991, after 1990, after the stipulation, 1992, August 19th, 1992, there are minutes of the Board of Selectmen. Linda Monroe, the town attorney at the time, was there. She says all legal matters have been taken care of. She says the planning and zoning has recommended the discontinuance of this road, and the selectmen then, Custer, I think, has a motion, a resolution to, once again, discontinue Old Road, the entire length of it, 145 to Russell Road. The entire length, breadth, everything. I sent you an article written by Mr. Slater's partner, Rich Roberts, published in the Connecticut Lawyer about 10, 12 years ago, called The End of the Road. And in it, I highlighted things, and amongst them was things like, even if the selectmen's actions aren't perfectly clear, common sense would say that back in 1989, when we sent it on to the town meeting, that was in and of itself a discontinuance by them, or they wouldn't have sent it on to the town meeting. And even if that is not, 1992, they clearly did. And in the case that was sent to you, Shoreline Gardens versus Stepantis, the court in that case found the selectmen discontinued this road in 1992. Now, I would disagree with the judge. I think they discontinued it in 1989. I think they discontinued it in 1974. But I do not disagree with the court's finding that they also discontinued it in 1992. The case of Shoreline Gardens versus Stepantis did not involve the town. It did not involve Pamela Fritz. It did not involve Hope Douglas. It did not involve the Cummings. Mr. Cummings is here. It did not involve anyone else who lived on the road. And it certainly did not name the town of Clinton. And therefore, I would say, is not binding. But it seems to me, from everything I've seen, it seems to me that that is what has been relied upon. The court in that case made a decision between Stepantis and Shoreline Gardens that there is a town road that it was not discontinued, the court finds. And because the customers of Shoreline Gardens are somehow considered the public, it's a town road up to the southern end of their stone wall. Thus far and no farther does that decision go. It specifically says we make no finding as to the rest of the road. So here's the crux of it. Do you have the full copy of the map that's at issue here?
The procedure.
Here's the other point. Even if that is what is relied upon for providing frontage, if you take a scale and put it on point D on Old Road, which is the dividing line, and measure over to the southern end of the stone wall, you've got about 80 feet. The zoning regulations require 130 feet. No matter how you dance here, there's not, the mistake is, even if you could rely upon a judgment that did not affect the town, that the public did not have notice of, even if it was only 80 feet of frontage, and that would be a mistake. So the main thing I would say to you is we are not here to ask you to defy a judge or a court. Not at all, because the judge's decision had nothing to do with the town, had nothing to do with Pamela Fritz, had nothing to do, it was not a party. The town could not appeal the decision, it was not a party. We're not asking you to defy a binding order, we're asking you to respect the authority of a Board of Selectmen in 1974 and 1989 and in 1992 that have a statutory right to discontinue a road, and we're asking you to respect the power of the town meeting, the legislative body of this town, to approve that. Mr. Roberts' article is dead on right when it says that the Connecticut Supreme Court has said it doesn't matter whether the selectmen discontinue first or or the town meeting says we approve, it's okay for the selectmen to discontinue. As long as the two things come into being, there's a discontinuance. So, to make it as succinct as I can, the ZEO does not have a choice of, well, I read this and I have the right to follow it because the judge said it, and judges are important. The ZEO has to, what we ask is to respect the power of the town meeting and the power of the Board of Selectmen, who have clearly acted to discontinue all of Old Road. But as I said, even if for some reason you could say, well, I have the right, the town has the right to do this, has the right to re-accept it, there is nothing that suggests that the town has accepted more than to the southern end of the stone wall. First of all, the court said that. Second of all, there is a document that Mr. Neff produced and sent to the state that said the town, certifying this by the way, that the town has accepted 200 feet of Old Road from 145, beginning at 145. Now, the addition is a little funny. 165 feet paved and 25 feet gravel. At 190, not 200 there, but in any event, there's not enough room for two lots with 130 feet. And certainly, this map, even if it can be changed, this map shows 80 feet of frontage, at most, because nothing after that could possibly be considered town road. Now then, let me just go on to my view of the law. The proper way to accept a town road, someone dedicates it, offers it, opens it to the public, and says, I want the public to be able to use this and enjoy it, and I have no control over who comes on. So that's the offer of the owners of the road. Then it goes to P&Z under 8-24. P&Z does not have a yea or nay on it, but it must advise whether we think this is a good idea or not. And then it goes to the town meeting, and the town meeting votes to accept it or not. So I would ask you, did any of those things happen here? No, no, and no. Not, there's no record of any 824. Let's take it back. There is no town meeting that has voted, and yet Mr. Neff said, certified to the state it was accepted, 200 feet was accepted, 1/13. Mr. Neff, or the town engineer, or the first selectman, has no statutory power to accept the road. So I don't know what it meant. And unless Mr. Neff is here, I don't know how anyone says what it meant. But there was no proper acceptance. We will concede, because we have to concede, that the town went and put in some curbing. It put in a stop sign. The stop sign, however, is in, by the way, the right-of-way of 145. One of the things that I did, and I'll submit this at the end, I called DOT, Norwich maintenance section, any work done in a state highway, mailbox, driveway, paving, any work needs a permit from the state. Carlos Wimberly, I believe is the name, asked him the question, for any permits taken by the town to put a stop sign here, or pave and join the road, or to stripe the road? Answer, we have no record in the past couple of years after the decision in the Tompkins case or the Shoreline Garden case of any permits being taken. So I don't know exactly how you accept the road when you don't even have the permits to finish the road. But that said, What I'd like to do is call a couple of witnesses as to put on some evidence here.
All right.
Mr. Stefanos, would you come forward?
Mr. Lambert?
Yes.
The handouts. You need that, Shirley?
Pardon me?
He said he was going to say.
Oh, you want to get that out?
I wanted, I would have to have some flow, and I assure you I will give you the things that I have mentioned for anyone else to see. So, Mr. Stefanos, where do you live? Where do you live?
Oh, 35 Old Post Road,
And where is that in relation to Shoreline Gardens?
directly across from the red.
Okay. Can you describe to me where the town's pavement ends?
It ends approximately 4 or 5 feet after the entrance of the red garden,
In relation to the stone wall?
right at the end of the stone wall.
Since the town paved to the end of the stone wall, has the town done any snow plowing beyond the pavement?
Absolutely not.
Has the town bladed or graded or filled in any potholes or done any maintenance to the unimproved section of the road?
No.
Are you aware of a yellow stripe running clear down to 145 in front of your property?
Yes, I am.
Did you paint it?
No, I did not.
Did the town paint it?
No, they did not.
Do you know who did paint it?
Yes, I do.
Who painted it?
Mr. Scott Baker.
Did he paint that stripe in the road before the lawsuit that he brought against you?
Yes.
And was that lawsuit 2011?
Yes.
Well, after the town repaved it, did he paint the stripe back again?
Yes, it
Was the stop sign there before the lawsuit?
did. No.
Was the curbing down to 145 there before the lawsuit?
No.
I don't have any other questions of Mr. Stefanos, but
Any questions, Mr. Stefanos? Thank you.
I assume there's,
If I could, do you have any questions? Thank you.
Yeah, I could answer one question.
Mr. Stefanos, may I have a look again? I'm sorry. You have a question. Also, as Eric's attorney, also would like to.
I just have one question.
Sure.
In 2011, did you understand this to be a public road? When you filed the lawsuit? I mean, when you were defending the lawsuit, did you file court papers?
We filed, they filed a lawsuit. The judge said he was not going to split it 80, his exact words. It's going to be all or nothing.
But you did allege in that lawsuit that it was a public road. It was a basis for your argument.
As far as we know, this view, he made a judgment.
I don't think.
All right. Went on.
Eric, do your attorney have any questions?
we don't.
Thank you.
Is Pamela Fritz here? Please state your name for the record
Pamela Fritz,
and your address.
14 Oak Road.
Where is 14 Old Road in relation to Shoreline Gardens?
The property is across from 14 Oak.
Where are you in relation to the Stefanoses?
They are my neighbor directly toward 145.
Can you locate on the map that's part of the ZBA's record, more or less where you live?
My property on Old Road is over here.
Stone wall camp,
That's stone wall.
right there in the parking area.
Yeah.
And is the frontage paved or unpaved?
Unpaved.
Does the town do any maintenance at all? Has Shoreline Gardens ever taken a position with respect to your ability to be on the other side of the road?
Yes.
And what was that position?
The position they took was that they owned that side of the road, and I was not to park a vehicle on that side.
Going back to, when did you buy it?
1987.
And in 1987, did the town do any maintenance of any part of Old Road, from 145 were you there, or were you involved with the discontinuance in 1989?
Yes.
And do you recall, were you at the town meeting?
Yes, at the time.
Was there in fact a vote, a unanimous vote of the town meeting on August 3rd of 1989 to discontinue all of Old Road? And back in 1989, all of the owners of Old Road in favor of discontinuing, all of the abutters?
Yes.
And did that include the Baker's predecessors, the Seals?
Yes.
Following that time, did the Seals run a business similar to the Bakers?
They have another garden center.
And did their customers continue using the road?
From 145.
Did people on Old Road stop members of the public from using Old Road?
Yes.
How did you do that?
We literally stopped people because of we stopped people, we arrest people and told people this is a private road, because it was a private road.
And was it marked private road?
Yes, it was.
Were your efforts at stopping people largely successful, stopping the public from driving on
Yes,
the
they
road?
were. Yes.
I don't have any other questions.
Anything there?
Mr. Chairman, I
Yes.
have not identified myself for the record. My name is Robin Pearson. I'm an attorney in front of Walter Pearson, LLC, members of the commission, and I'm here on behalf of the Bakers. I just wondered if I could ask Mrs. Pitts a question also.
Absolutely. We have no comments next year.
Even if I did, she has the right to explain.
If I may?
Sure.
Well, I would just like to understand, you said you personally went out and stopped people in front of your house from,
Yeah, when
Using the
people
road?
came by, this was something that all of us that were in agreement on the road, and it had been discontinued at a meeting. We actually did stop people. We would question people as to whether they lived on the road or didn't live on the road.
and did anybody after that from the public come down that road from the north towards the garden center?
And no, there's never, the traffic to the garden center when the sales had it was never from, ever,
Was never what?
never came from Russia.
Where are you located? Your residence is north or south of the property that's owned by the Bakers now?
That's considered, I'm across the road from them, so how does that consider? North? East. I'm just doing this direction.
So it's pointed out towards that where your property is. Okay, thank you.
Okay?
Yes, I have just one more person I want to call, that's Mr. Cummings. Would you state your name and address for the record?
Kirby Cummings, 30 Old Road.
When did you purchase your property well, where is your property located in relation to Mrs. Fritz and Oak Dock?
My property favors the Brush Hill. I'm on the opposite end of the road.
Are you, first people are Sponkus, correct?
Yes.
Fritz?
Yes.
Next one is Hope Douglas?
Douglas.
And when,
And that's,
okay. Does the town, have you asked the town to maintain or do anything on Old Road?
yes.
And what does the town say?
No, we do not exist. We are not a town road. I even had a hard time getting a dump pass. They said it exists.
Does the town, is Mr. Saponkis' testimony correct? The town does not plow or do any maintenance beyond the pavement?
Nothing at all.
And that's before 2013 and before?
19 years, I've never seen the town worker on our road. We call, they will not come. We have paved plowing. I personally built potholes from Brush Hill Road to the edge of my property, and I can't afford to do any more. I wish I could. It's a veritable riverbed. It's not maintained. If you do not have four-wheel drive, you cannot come down Old Road. The pavement that I see literally looks like a driveway, not Old Road. It does not help us at all. And, no, I've never.
This is coming up at 145. is it not?
145.
Right, and it comes up to, it goes into Shoreline Gardens.
Correct. It doesn't even have the appearance of being the beginning of the road. It just looks like an entrance to a business. After that, it's just a dirt road. That literally looks like a river.
Yeah, no, that's all.
Any questions for Mr. Cummings? No? No? Okay. Thank you, Mr. Cummings.
So I was digging through, well, I was going through some of the things I want. This is the 1971, I title is 1971 list of quote locally maintained roads submitted by the town to the DOT. The town claimed it maintained 0.06 miles of Old Road, then called Brush Hill Road 2. I have a 5-page document for all of the roads in town, and I typed on it next to Brush Hill Road. Note in the 1950s and 1960s, what is referred to as Old Road is called Brush Hill Road 2.
I'm just trying to understand your position here and the purposes. You say you're not challenging the Superior Court decision in Shoreline Gardens versus Sponkus?
No, I am saying absolutely the opposite. I am saying it is wrong. It is factually wrong, and it doesn't, it never bound the town anyway, because the town is not a part of it.
So you want, so what are you asking in this appeal, that the town ignore this decision on the basis that it was improperly reasoned by the judge?
No, well, I guess perhaps what I'm saying is different. I believe the town has no ability without acting on its own, and it is not bound by a decision. It is not a party to a decision. That when its legislature approved the discontinuance and its executive body on at least 3 occasions did everything it could to discontinue the road, that the town is supposed to respect the government positions that are binding, which are those.
Okay, but why is this the forum to challenge whether or not the town should be bound by that decision? Since it is a decision the town apparently has accepted it to a certain point. I'm trying to figure out whether or not you are.
What I am saying is
strictly the.
What I am, no, let me try to listen to you and try to answer your question. It is my position that it is not for the ZEO to to go reading decisions and deciding which ones apply. Similarly, it's not Mr. Fritz's position. He's the executive officer, he's supposed to enforce, whatever his charter powers are. But generally speaking, the selectmen act by majority vote of a board, not by, for example, and we have no evidence, by the way, that Mr. Fritz said, yeah, that looks good to me, go do it, Mr. Neff. I don't know why, and why Mr. Neff did it, that hasn't come out. It may come out in evidence, but it hasn't come out yet. And Mr. Neff is not in the position to go reading decisions and saying, despite the fact that this is a discontinued town road, I'm going to take town money and town labor and go out and put a stop sign in without going to the DOT. I'm going to pave it, and I'm going to call it a town road. What I said was there is a procedure for creating a town road. And so all I said is in not challenging it, even if it is correct, it only goes far enough to get 80 feet of frontage in when the zoning regulations require 130. And so either way, Mr. Knapp erred in saying this meets the regulations.
Okay, so there's two issues. One is you are challenging the judge's decision that it is a town road from 145 to a certain point.
Yes. And the reason being that that his decision says there was the town meeting never met. And I put on evidence that is incontrovertible that the town meeting did, and since the town wasn't a party, the town never got a chance. If you had been there, you would have been bound to have submitted that evidence to the judge. There it is, Your Honor.
I'm just trying to help identify what the issues are.
Right, but all I'm saying is, and I'm trying to be as straightforward as I can. I'm a lawyer, I have a great deal of respect for judges. But if you're not bound by it, and someone else can show that in fact the factual basis was wrong, then I can't understand why the zoning enforcement officer would say, I'm going to embrace a decision that does not bind my town and has been proven to me to be wrong. There were two things in that decision, and I mentioned them in my letter. The judge says, first, there was no meeting. And the town never had a chance. It was never given notice. If you're declaring, by the way, I would think it would be declaratory relief to have notice in the newspaper for all of the people of the town, not just serving the town clerk or something, but I'm not sure, unimportant there. Second was, he says, there's no evidence of any deeds to people on the road. That troubled the judge, except that former Judge Monroe, in her letter, says what's absolutely correct. You don't need a deed when a road is discontinued. Nowadays, subdividers are usually asked by towns to give a deed to a road when they're done. I don't know if your town does it or not. But that is not what makes a road. A road has always, by law, been an easement of the public for travel and a number of other purposes. So that from time immemorial, the people owning the property adjacent to it have always owned the middle of the road. Always. But that ownership, when there is a highway, is burdened by your and my right to travel, and so by convention, surveyors only show the ownership up to the edge of the road. But once the town discontinued, just as there was no deed to the town for the highway, the town meeting went and said we accept it, or the selectmen laid it out, and the town meeting accepted it. However it came into being, there was never a deed from the adjacent people to the town. Similarly, when the town says we have nothing to do with it, there's no deed back. So yes, I'm saying that this board should consider it to have been an error by Mr. Knapp. I'm not saying a bad error. He had the thing. He had someone. Maybe we haven't gotten that. Haven't gotten any evidence of that. Whether he had that information before or not, or whether he got it after I brought the appeal and is now using it to justify. I don't know. The evidence isn't here. I have no idea.
I got the second point that you made about the lack of frontage.
Mm-hmm.
Could you show us on the map what
Sure.
you're talking about?
May I mark this map up a little?
Yes, Charlie.
The dividing line between Lot 1 and Lot 2, it didn't exist until June 29th of this year, so it's not my grandfather. A, B, connect the dots here, C, D. Okay, and then, so I'm going to put a squiggle across Lot 1's frontage, and I'll put some line, vertical lines, or horizontal, whichever you're going, across Lot 2's frontage. So if you take, you measure from back there to where the judge said was the town road, it's about 80 feet. And 80 feet is not 130 feet. And 200 feet, whatever it was, and we don't know how it's measured from the road, we don't know whether it's measured here, or from the right of way, who knows, but it doesn't get us,
Just take a look.
oh no, it's a lot wider, it's a lot wider than that, but wherever it is, there's not enough, that's the starting point of the frontage, and this map says I've got 531 feet. But all the testimony here, and no one's challenge is, everybody who's passed that pavement gets no plowing, no maintenance, no scraping, no anything. And so my position is it was discontinued, and clearly the town still ignores it. And therefore you can't count that as the type of road that is acceptable for frontage. That's all. This is following 1971. I told you the 1972 list of locally maintained roads. I say the town, quote, washed its hands, end quote, of Old Road, or Brush Hill Road 2, or Old Brush Hill Road. Since 1972, the town did not consider any part to be town road. I'd like to submit that.
I have a question for you.
Let me try to answer.